weeks already this year, then you only have up to 6 weeks of EFMLEA time available to you. And if you've fully exhausted your FMLA leave already, then you're not granted additional time, but you can still qualify under the Emergency Paid Sick Leave Act. So who's covered? Employers for both acts, it's going to be the same definition. It applies to private employers with fewer than 500 employees and any public agency with 1 or more employees. So basically all public agencies. And just something to note. So the FMLA, as I mentioned, already exists. It has this is a different standard than under the FMLA. So normally under the FMLA, it applies to companies that have 50 or more employees within the last 12 calendar months in a 75-mile radius. Whereas this one is just any company under 500 employees. If you're a company that previously didn't meet the FMLA definition, but you do have less than 500, you are covered by the EFMLEA, but only for the EFMLEA. You don't have to start providing coverage under the FMLA for any of the other qualifying reasons. Now, as far as the employees, the EPLSA applies to any employee of your company versus the EFMLEA. It has to be someone that's worked for at least the last 30 calendar days. Oh, and I should have mentioned there's some exemptions for healthcare and first responders and some federal workers. They may or may not qualify. You need to check on your specific situation. So the reasons for leave, there are 6 qualifying conditions that would allow an employee to take leave under the EPLSA. They're listed here. I'm going to go over them in a little bit more detail in a second, but it's only these 6 qualifying conditions. Versus the EFMLEA, there's only one that qualifies, and that is if the employee is unable to work due to a need for leave to care for their child, if the child's school or place of care is closed due to the health emergency, or child care providers unavailable for COVID-19 related reasons. And as we go through the 6 reasons that I just mentioned a minute ago, you'll see that this is the same as number 5. So the Paid Sick Leave Act is a little bit more broad as to who it applies to. The EFMLEA is just if you're caring for your child because of a school or daycare closure. Here are those 6 categories again. I'm just going to go through them briefly. The first one is if an employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. And now here's where I was saying that things are changing. The recent Department of Labor guidance has included that or expanded that to include if you're subject to a shelter in place or a stay-at-home order that's issued by a federal, state, or local government. And it may also include advisory orders for certain categories of citizens. So for example, the state of Florida executive order says that senior citizens and individuals with significant underlying medical conditions shall stay at home and take measures to limit the risk of COVID-19. So that would fall under category number 1. The second one is that the employee has been advised by a healthcare provider to self-quarantine due to the concerns related to COVID-19. And that has to be, again, a healthcare provider, believing that you either have COVID-19, you may have it, or you're really vulnerable. Does not include someone just self-diagnosing and deciding to self-quarantine.
Does that, just a quick question on that. Now, so does that include, like, say you have a family member who they suspect might have it, and so telling the family member to quarantine, so then that obviously people that are with them might, would be at risk as well. Is that clear or no?
You may be able to qualify under what I'm going to show on the next slide, a different reason, but if a healthcare worker says you and your entire family have to now self-quarantine, then I think that would be covered because a healthcare provider is telling an individual you need to quarantine. One of the things, and I'm going to go over some of the required documentation later on, but just as a precursor, I really recommend that all employers and employees are just documenting as much as they can right now. Whether it's, I'm going to see a doctor and maybe you test negative for COVID-19, still make a note of when you went to the testing facility, when you got your test, what the test result was. Just kind of keep documentation of anything related to time missed from work, or your children, time missed because you're taking care of children, any of those kind of things. Just try and document that, because that may be important later on.
Okay.
But I think if a healthcare provider said your whole family needs to quarantine, that would cover under number 2. So number 3 is if you yourself, as the employee is experiencing some symptoms and you're seeking a medical diagnosis. So this one authorizes you to take leave for the time that you're unable to work because you're taking affirmative steps to obtain a medical diagnosis. And this includes awaiting test results. So let's say today is Wednesday. You had to take a half day off because you wanted to go get tested. You're showing some symptoms. You go to the testing center, closest to you, and it takes you half of a day to get your test performed. And then at the end of the day, when you get your test, they say, okay, don't go to work for 3 days because you need to wait for your test results and just don't be around people. So you get your test results, let's say on Saturday, and they're negative. You can take leave for that half day on Wednesday that you went to go get the test, and for that Thursday and Friday that you were awaiting your test results because the doctor told you not to go. So that would all qualify. Now, it doesn't apply, again, to someone that's just self-quarantining without seeking a medical diagnosis.
Gotcha.
And then number 4, I think, is what Sandy, what you were saying is, and maybe not, but number 4 is if an employee is caring for an individual who's subject to either the order described in number 1 or who's been advised as described in number 2, which is the medical diagnosis. So if your family member is told they need to self-quarantine and you need to take care of them, then that would fall under here. Now, it has to be based on a genuine need to care for the individual. And that individual must be either an immediate family member, a roommate, or someone similar that you have that relationship with. It's not my neighbor's cousin's nephew that I need to go and look in on and see. That would not fall under number 4. Number 5 is probably the most common one that I think we're going to see right now, and that is the employee is caring for his or her son or daughter whose school or place of care has been closed or whose childcare provider is unavailable due to COVID-19 related reasons. As I mentioned, this is the same one that overlaps with the EFMLEA. It's the only reason you can get that type of leave. Now here, the Department of Labor has expanded that definition of son or daughter to also include a child over the age of 18 if they're incapable of self-care due to a physical or mental disability. That was a question in that interim period before we got some guidance, so that's been answered. It's also only available if the employee needs to and actually is caring for the child. So if there's another individual, such as a parent, a grandparent, or their usual child care provider that's able to care for the child, then the employee is not entitled to take leave. So a good case in point, there are a lot of daycare centers right now that are still open. And there are parents who understandably don't want their children to be going to daycare during this pandemic. Well, unfortunately for the employee, under this leave provision, they don't qualify because that child care center is open. They're electing not to send the child. So that they would not meet the qualifications under the FFCRA for that. And then finally, number 6 is just sort of a catch-all provision that the employee is experiencing any other substantially similar conditions specified by the Health and Human Services or the Department of Labor. I haven't seen that come up yet. So, okay, those are the 6 under the Emergency Paid Sick Leave Act. And then again, number 5 is the same as the reason for the Emergency Family Medical Leave Expansion Act. So the rate of pay, if you're doing it under the EPSLA, those first 3, whether you are under a government quarantine order, you're self-quarantining because of a medical diagnosis, or you're awaiting test results or medical diagnosis. Those first 3, you can get your regular rate of pay up to $500, $511 a day, or $5,110 total. Those last 3 reasons, the taking care of a family member, taking care of your children, or the catch-all, you only are authorized to get 2/3 your regular rate of pay, up to $200 a day or $2,000 total. Under the EFMLEA, the first 2 weeks are unpaid, but you can use that leave under the EPSLA during those 2 weeks. So you still are getting paid, it's 2/3 rate. Or if you had sick time or vacation time or whatever accrued at your through your employer, you're allowed to use that paid leave, and you have to be compensated at whatever your business sets that type of leave at. The remainder of the FMLA or EFMLEA time up to the 10 weeks is 2/3 rate of pay up to $200 a day, capped at $10,000. Now, one important thing is you have to pay at least minimum wage. So if 2/3 rate of pay is less than minimum wage, then you have to pay your employee at least minimum wage. It's whichever one is higher. Okay. So the next thing is, are you required to pay overtime? Under the EPSLA, you're only required to pay 80 hours total. So if you're scheduled to work 50 hours a week, then you have to pay your employee 50 hours for the first week and 30 hours for that second week. You don't have to go beyond 80. But under the EFMLEA, yes, you do have to pay overtime if the employee is scheduled. So again, if you're scheduled to work a 50-hour work week, you have to get paid for those 50 hours. But if you're an employee who's only scheduled at 40 hours, but you occasionally maybe work 42 hours, you're only going to be paid for those 40 hours because that's what you're actually scheduled for. And just as another note, this overtime pay doesn't have to include a premium. So if you usually do time and a half for overtime, you don't have to pay that extra time. And you're still subject to the cap of the previous slide. Can you require your employees to use other leave first? Under the Paid Sick Leave Act, the answer is no. You cannot have any other leave be forced to be used first, because this is supposed to be in addition to and not a substitute for any other types of leave that you may provide your employees. However, under the EFMLEA, an employee can choose to use, or the employer can require the employee to use, any of their time that they've accrued through their work concurrently with the EFMLEA. And you say, why would I do this? If I'm an employee, why would I choose to do this? Because if you're using employer granted leave, you have to receive your full rate of pay. And as an employer, you can force your employees to do this, and it runs concurrently. So then that way, you know, your employee doesn't come back from having 12 weeks of leave and then goes and takes a 4-week vacation. Is leave available if the work is otherwise unavailable? And this is a big one. The answer is no. If the employer does not have work for the employee, then leave is unavailable. So you really have to look at the cause of why an employee is unable to work. And the Department of Labor gives this example. If a coffee shop is temporarily closed because of a downturn in business, then there's no way for that employee to work because the coffee shop is closed. So they would not meet any one of those qualifying reasons under the FFCRA. So you really have to look and see why. Now, if the coffee shop is closed because all of the employees are under now a stay-at-home order, well, if it's an essential business that's still open, but the company decides to close, that may be a different story. So this is one of those really tricky ones that you have to look at the underlying cause of why the work is not being done. What about if an employee can telework? So you can't take leave if you have the ability to telework and the employer is going to let you telework. They're allowing that. There is work for you to do, and there are no other circumstances that prevent you from working. So if you can telework, the government has actually said they really are encouraging employees and employers to work together to try and come up with a way to telework, because if you telework, you're entitled to your full rate of pay for your reported hours. And that, excuse me, I thought I was gonna sneeze, that does include overtime. Now, one thing with that though, certain labor laws say that you have to be paid if you start working at 7 a.m. and maybe you take like an hour lunch break, but you do some more work, and then, you know, you got to feed your kids. So you stop for a little bit and then you do a little bit more work, and now it's 9 p.m. Some labor laws say you have to pay from 7 a.m. to 9 p.m., even if you're not working the whole time. That is not the case here. You're only entitled to be paid for the time you're actually working. But now if you're teleworking and all of a sudden you meet one of those other qualifying conditions that make you unable to work, then that leave does become available. Are there any exemptions? And the answer is yes. If you're an employer with less than 50 employees, you may qualify for an exemption for just for your employees taking leave to care for children. So and the only reason you can qualify for the EFMLEA and for the EPLSA, that's only category number 5. You have to show that your leave payments would jeopardize the viability of the business as a going concern. And there's 3 different conditions that have to be met. And you can see them here. It's that the leave would cause the expenses and financial obligations to exceed your available business revenue, and cause the small employer to cease operating at minimal capacity. In the absence of those employees would be a substantial risk to the financial health or operational capacity because of any specialized skills, knowledge of the business, or responsibilities. And then finally, that you can't find other workers essentially to replace them. Now, again, if those 3 conditions are met, then you can deny paid sick leave or your expanded family and medical leave only to those eligible employees whose absence causes these small employers' expenses and financial obligations to exceed available business revenue, poses substantial risk, or prevent the small employer from operating at a minimum capacity, respectively. That all is exactly a direct quote from the Department of Labor. And the reason I wanted to put that in here is because this is not an exemption where you're going to be able to maybe apply for it now and find out whether or not you qualify under the exemption before you start making these decisions. This is one of those things that is really not going to be known whether you qualify by government standards or not until after this whole crisis is over. So I wanted to give you the exact language that the Department of Labor is advising at this point. I have talked to some of my clients about this exemption. It's completely up to you as a small business owner whether or not you want to utilize it. But as this is entirely new, we don't really know what courts or the government are going to deem to actually qualify for this exemption. And so there's a small risk that if you deny leave now to your employers, that you may not have met the qualifications that they're intending, and that may cause a problem down the road. So it's a business decision whether you want to take that gamble. You have to document all these facts and circumstances that meet the justification for this denial, because I would guarantee that the Department of Labor is going to come back after all of this is over and double check businesses that took advantage of this exemption. So again, that's just something I am cautioning my clients. That's up to you whether you want to take that risk that you may or may not meet this exemption at the end. So the penalties, it's considered a failure to pay minimum wage if you don't comply with the EPLSA. And then as always, you're prohibited from discrimination, discharge, discipline, and retaliation for any employee that's choosing to take leave. That's nothing new. I hope everyone knows that you're not allowed to do that already. And then under the EFMLEA, you cannot interfere with, refrain, or deny any employees exercise to any right under the EFMLEA. It's the same, again, as the FMLA. Just don't retaliate against anyone for taking leave. That's the gist. Documentation. I mentioned this earlier. It's really important. Any employee that wants to take leave under this act, you have to provide your employer with documentation to support that leave. And it has to at least include a signed statement with your name, the dates that you're requesting leave, the reason for the leave that is a COVID-19 qualifying reason, and a statement representing that you're unable to work or telework because of that reason. That is the minimum amount of information that the Department of Labor is requiring. But then based upon your reason, you may have to provide additional information. So for example, if you're taking it to care for your children, you have to provide the name of the child being cared for, the name of the school or the daycare that's closed, and a statement representing that there is no other suitable person available to care for the child. If you're taking care of another person, you have to show why they're out. So you have to be able to provide that otherwise maybe personal information, but it's required under the act to take that leave. And then as an employer, you are required to retain all documentation provided for 4 years, regardless of whether you actually grant the leave or not. They didn't specify what form of retention is required. I'm sure that digital retention is going to be acceptable. Sorry, my dog is barking at the thunder. So I'm sure that digital is going to be fine for now. If you have originals, keep those. But I would encourage people to develop forms. I've developed forms for my clients that they can use, like a standard leave form, things like that. But just, it's really important to maintain that documentation, as I said before. And then about reimbursements, there are going to be some reimbursements available through refundable tax credits. I'm not a tax lawyer, and so for this, I would suggest you speak to your accountant or go to the IRS's website. They've got a bunch of forms and additional documentation that you may have to keep just to apply for these reimbursements for the money you're spending on this paid leave. And then finally, do you have to tell your employees about the leave available to them? Yes, you do. All employers,
That was going to be my question. Whose liability is this? Okay.
So all employers are required to post notice in a conspicuous place on site of their employees' rights under the FFCRA. Now, what if you're a business that is entirely working from home or teleworking? You can email the notice to your employees. If you have one of those fancy HR portals, you can put that on your HR portal. It has to get out. You can do it the old-fashioned way and support our USPS and mail it to all your employees, but you do have to give them notice. If you go on the Department of Labor's website, I put a hyperlink there, which I know through a webinar is not really helpful, but if you go on the Department of Labor's website, they do have a sample notice. You can just print that out and stick that up on the wall, and that is totally satisfactory. And then
Notice.
go ahead.
I said, Danielle, take notice.
Oh,
I'm notifying.
take notice. You have to post it in a conspicuous place.
Oh, my bad. Post it in your restroom on the.
And then the next question is, do you have to restore the employee to their position when they return from leave? In most cases, yes, you do have to restore the employee to either the same or an equivalent position when they return from their leave. But having said that, an employee is not protected by any employment actions such as layoffs that would have affected them regardless of whether the leave was taken. So if you are deciding to eliminate 50% of your workforce in the certain category, and that person happens to fall in that 50% in that category, then their job is not protected just because they're out on leave. And then there is another exemption available for employers with less than 25 employees under the EFMLEA. It's a little bit more complicated, so I didn't really want to get into it today. If you do have less than 25 employees and you're not sure about restoring someone to their position after they get back, because maybe you had to hire someone in the interim to take over their responsibilities, you definitely need to talk to an attorney about that before you make any employment decisions there. Healthcare coverage, it's basically status quo. So their employees are still entitled to their healthcare coverage under any group plan that you may have on the same terms as if they are not out on leave. Having said that, the employee is still responsible for paying for any part of their premium that they did before taking leave. So again, it's supposed to be status quo. That is all I have prepared, but I am happy to answer any questions that anyone has.
The only thing I was just, I know you talked a lot about hourly. I'm assuming that it's the same for salaried employees, that there's not any caveat in any of that.
No, it is the same. Full-time employees are treated the same, whether they're hourly or salaried.
Okay. I can't think of anything. I know, you hit a lot of really great stuff. Danielle, can you think of anything that?
Nothing that comes to mind. I think you did a really good job explaining things and being very thorough. I would just say that as people watch this, and if they do have questions, please reach out to Elizabeth. Obviously, her information is on the screen right now. elizabeth@johnsonturner.com.
Which kind of-
So, and if you have trouble with that, reach out to us at the chamber and we'll get you into contact with her so that you can have your questions answered properly. Elizabeth, I think you did a great job. Thank you very much.
Thank you so much, Elizabeth. And as you all at home are watching this or at work or wherever you might be right now, if you have thoughts on things, topics that you would like us to cover in these Ask the Experts, our goal is to do at least one a week. We might actually, I think next week, we're looking at maybe doing 2 next week. So if you have a topic though, that you really feel like is something that would be beneficial to multiple people, please let us know so that we can look for someone that might be able to answer those kind of questions. I appreciate each and every one of you tuning in to this. The Leesburg Area Chamber of Commerce is here for our businesses, and we are here for our community, and we are all going to get through this together. So thank you so much, Elizabeth. Thank you, Danielle.
Bye.
And the bark came after.
I don't know. Okay, hold on.
I'm assuming, Danielle, you're turning this off.